Welcome to this guidance on data protection, which is part 3 in our series on documenting coronavirus in Warwickshire. If you're watching this presentation, chances are you agree that archives play a vital role in our society. Their importance stems from the information contained within the records you are caring for, information that often relates to people. Where you are looking after records about people, you will need to consider how data protection may affect your activities. You will also need to ensure you understand how to safeguard the personal information given to you by members of your group, volunteers, and the depositors of records to your archive. Data protection is about treating people's information fairly and responsibly, and is there to protect everybody. The law supports the archiving of personal information that is worthy of permanent preservation. In the UK, the law is set out in the Data Protection Act 2018 and the General Data Protection Regulation. The Information Commissioner's Office regulate data protection, and our current Commissioner, Elizabeth Denham, used to be an archivist. You can find a lot of useful information on their website to help you comply with the law. The National Archives have also created a detailed guide about how the law applies specifically to archives. You should read this to help shape your processes. Most of the records that you will be archiving will contain some amount of personal information. You will need to take particular care when dealing with information that relates to health or criminal matters. This is because the law provides extra safeguards for what is referred to as special category data, that is, data that is more sensitive. Therefore, if someone gives you an account of their coronavirus illness or details of a fine that they received for breaching the lockdown, you will need to be more cautious with this information. You can find out more about special category data on the Information Commissioner's website. Children's data is also afforded more protection under the law. Information that is not classed as personal information includes records relating to someone who has already died. If you don't know if someone is still alive, the National Archives guidance recommends that you presume the person has a lifespan of 100 years. Fully anonymised information is also not classed as personal information. There are 7 principles which should underpin how you use personal information. You should ensure you treat information in accordance with the law, fairly and transparently. You should only use information for the original purpose that it was collected, and only collect the minimum information that you need. You should ensure information is accurate and kept up to date. Information in archival records is not expected to be updated in the same way as information about volunteers or depositors. You should only keep information for as long as it is needed for the original purpose it was collected. However, the law does recognise that there is a public interest in keeping records worthy of permanent preservation, and there are various exemptions for archiving in the public interest. You should ensure information is kept securely. The law states that you are accountable for compliance with data protection legislation, and you must therefore take responsibility for it. You must keep any personal information that you hold securely. The level of security that you require will depend on the nature and age of the personal information. If you hold any special category data, you must ensure that this is kept more securely. You should also consider the security of any digital records that you hold, for example by checking any software that you use to make sure it is trustworthy. When you take in records, you will need to check whether they contain any personal information. If they do, you will need to carry out a risk assessment to decide whether or not you can make the records available to the public, or whether they will need to be closed for a set period of time. You will also need to be careful when describing records in your catalogue or finding aid to make sure you don't share personal information in error. You can find a checklist of questions to ask yourself when accessioning in the National Archives guidance. You should make sure you have a published collections policy, as this will help you to demonstrate that you are only taking in what is necessary and relevant for archiving purposes. Access to personal data in archives may be possible for historical research, providing that certain safeguards are met. Researchers should be asked to sign a declaration form before looking at records that contain personal information. The form should make it clear that the researcher is now responsible for complying with data protection legislation. It should also explain that their research must not cause any substantial damage or distress to any person, and no one must be identified in the results of their research. The law gives people certain rights in relation to their personal data. People have the right to be informed about what you will do with their information. You should create a notice explaining how their data will be used and make this available before you collect any personal information from them. You could upload your privacy notice to your website and refer people to it when you collect their details. The ICO website has some templates you can use to help you create your privacy notice. The law gives people certain rights in relation to their personal information. You should be aware of these rights and know how you will deal with any requests that you receive that relate to them. People may ask to see what information you hold about them. They may ask you to correct or delete their information. This could obviously prove challenging where we are dealing with archival records. Whether you are required to comply with a person's request will depend on many factors, including whether the information is archival. This is because there is a specific exemption to some of the provisions of data protection law if you are processing information for the purposes of archiving in the public interest. For example, you do not have to comply with a request to delete information from an archival record if it would prevent or seriously impair your ability to carry out your archiving activities. You can rely on this exemption providing that you are not likely to cause substantial damage or substantial distress to any person. The information in the record must also not be used to make a decision about anyone. You can find out more information about how to deal with people applying to exercise their rights on the Information Commissioner's website and in the National Archives guidance. Here are some resources to help you to comply with data protection legislation. I hope you found this guide about data protection and archiving useful. Thanks for listening.